My time for rebuttal.
Certainly.
Thank you. Your Honors, this court should reverse the ruling of the Knox County Criminal Court granting post-conviction relief to Mr. Linzy because the court erred in determining that Mr. Linzy's trial counsel, Kit Rogers, rendered ineffective assistance of counsel with respect to how he, I believe the criminal court's wording was, dealt with and addressed the social media evidence in this case. Given, Your Honors, that I'm challenging the post-conviction court's order granting relief on an ineffective assistance of counsel basis, I'd like to spend a brief moment discussing the standard of review because there's sort of a split standard when it comes to review of these sorts of orders. To the extent the state is challenging any factual findings by the trial court, I absolutely recognize that those are given a great deal of deference by this court and that it's on me to show that the record preponderates against them. However, to the extent the state's argument, which I believe it principally is simply challenging the legal determinations on deficiency and prejudice, that is something this court reviews de novo. I just felt it prudent to address that split standard given what I'm going to ask the court to do. Because I think the problem we have here is one of error in the trial court's legal determinations. What this entire post-conviction became about, and it has, as this court will see from the record, it had a bit of a tortured history winding its way through the post-conviction process, hearing multiple briefs. I think there are even post-hearing briefs in this case before the orders returned. What this really centered on was the way in which Kit Rogers, trial counsel in this case, handled the objection to certain Twitter records. And the importance of these Twitter records to the state's case was sort of as complementary proof of motive. Two witnesses, one of whom was the eyewitness to the shooting that's what was the basis for this original crime. So that witness, and then one other testified at trial. Look, we knew that the victim in this case, Mr. Dominic Johnson, and the defendant, Mr. Jabriel Linzy, we knew they didn't like one another because we'd seen them sort of fighting on social media. So that's testimony from these two witnesses. And then the state introduces these Twitter records. There's a great deal of other evidence in this case, which we'll likely discuss later. But that's really the function of these Twitter records. This is this complementary evidence of motive for first-degree premeditated murder. This is just a continuation of an ongoing disagreement between these two people and the gangs they're affiliated with. That's the function of the records that end up being central to the post-conviction. And what the trial court says, based on the post-conviction petition, is I take to sort of be two things. The order's a little unclear what exactly the trial court is found was ineffective. I think the court could be saying one of these two things. One being Mr. Rogers should have raised a relevance objection to these Twitter records. So that's sort of the way I principally interpreted the order. The second thing the post-conviction court could have been saying is, well, even if you will put the objection aside, he should have made certain arguments to the jury to, as I take it, undercut the weight assigned to these records. And I'd like to first address any potential ineffectiveness and deficiency with regard to not making a relevance objection. And I think where we need to start when judging whether or not Mr. Rogers was ineffective for not objecting on relevance is how Mr. Rogers treated the Twitter records at trial. And the trial transcript was Exhibit 1 to the post-conviction hearing. And what we can see from the trial record is that Mr. Rogers is basically, as soon as trial starts, it's the morning of the first day of trial, says to the trial court that he objects to any introduction of these Twitter records to support the assertions of these two witnesses, Mr. Blair and Mr. Spears, that there's sort of a Twitter beef between the defendant and the victim. He objects very specifically on authentication and hearsay grounds, and then he later objects on 403 grounds. So he raises ultimately three different objections: 403, hearsay, authentication. When we get to direct appeal, authentication is presented, as is, I believe, 403. Hearsay is abandoned by that point. What he doesn't object on is relevance, but that's not to say that the record from the trial is silent as to his thoughts on relevance. He affirmatively says, I concede that these could be relevant. I think he later says, I can't argue that these aren't relevant. So what we have from the trial record, from trial counsel's performance, is him recognizing that a piece of evidence is potentially problematic, him assessing 4 separate legal grounds and choosing to raise 3 of them because he doesn't think that the 4th is meritorious. And Your Honors, that is sort of classic trial strategy. Maybe the paradigmatic paradigmatic example of trial strategy is a trial counsel choosing what issues to raise. But then when we get to the post-conviction hearing and there's this challenge saying he's ineffective for not making this objection, there'd be a pretty formidable burden in showing something that appears strategic. He's aware of all these issues. He's choosing which ones to raise. Is somehow...
Mr. Garrett, Mr. Ward, I'm sorry. What's problematic to me about, it's quite unusual that you see the state in your position, because it's very rare that we see the grant of a post-conviction petition. The content of the tweets is what is troubling, because from my very elementary background on tweets, it contains some very violent words directed toward the victim, but it wasn't the victim, it was someone else. It was very aggressive words towards the victim in this case.
Yes,
and is that not why the trial court was troubled by the failure to exclude the tweets in this case? Because they really didn't have anything to do with this victim. Well, it had to do with someone else entirely.
Well, Your Honor, I think I'd respectfully disagree that what the record shows is that the tweets have to do with somebody else entirely.
Okay.
What the record shows with respect to the tweets, and I'll apologize if I get some of I'm not going to try to recall the different usernames. There's a certain set of tweets that are indisputably sent to the victim in this case.
Right.
The victim in this case has the nickname Domo.
Right.
He has a certain Twitter handle that contains Domo in, I guess, the Twitter name. There are other tweets that refer more generally to a Domo, not in any part of any Twitter username. And then there are some other tweets sent by Mr. Linzy that reference that I guess tag or identify another Twitter username that also contains Domo in it. And the state's contention at trial was that all of these pertained to the victim. At the post-conviction, admittedly, there was a little bit of evidence introduced about, I guess, the defendant having a disagreement with a man named Dominic Booker, who also had the nickname Domo.
So that wasn't in the tweets? That wasn't?
There's nothing in the tweets that indicates that this is about Dominic Booker, no.
Okay.
It perhaps could be argued, but we're well short of the tweets affirmative, like there being any affirmative tie of the tweets that were introduced to this other person. What also isn't present in the record is any indication that Mr. Rogers, when he's dealing with these tweets, which, have the nickname Domo, all are sent to or reference a person named Domo. Mr. Rogers knows that Domo is the nickname of the victim. There's no indication in this record, there's no proof that he understands there is another Domo at play when he's dealing with this evidence. And I think that's part of the problem is there are some, I think there's some concern by the trial court that with evidence that later came to light, maybe other arguments could have been made. What's not present in this record, though, is any indication that at the time Mr. Rogers is trying in this case, he understands there's this other Domo out there. I think the closest we come in the record to having that is Mr. Rogers saying, I knew that my client was involved in a fight at school, but he recalls zero details about that. And then Mr. Linzy doesn't provide any testimony that fight at school, any testimony himself about telling Mr. Rogers that fight at school was with somebody named Domo. There is testimony from, I believe it's Mr. Linzy's high school principal, that says he was involved in this fight with Dominic Booker. But what's missing is and since we're judging trial counsel's performance, this is important, what's missing is any link between trial counsel and him having that knowledge. And what we don't have, I understand my friend on the other side.
Should he have?
There aren't factual findings that would support that, Your Honor. I understand that my friend on the other side in her brief has said perhaps the problem here is one of investigation, but that's simply not what the post-conviction order says.
Well, that's my question. When and how, follow up on Judge McMullen's, when and how did the allegation this involved a different Domo, when did that come to light?
So when it first came to light, I can't exactly say. The first time it appears in the record is when I believe it's Mr. Adams is the principal, when he testifies at the post-conviction hearing, and then it's I believe the fight is referenced in some of the post-conviction pleadings.
But that's your contention that even what was presented at the post-conviction hearing, it's not clear.
It's certainly not clear insofar as what is not shown at the post-conviction hearing is knowledge by Mr. Rogers. And what I'd also say the post-conviction hearing doesn't show is some indication that Mr. Rogers should have known about this. There's no statement from Mr. Linzy like, oh yeah, I told him that I'm fighting with this other guy named Domo. There's no statement from Mr. Rogers saying, oh, I understand that there's this other Domo out there. With the benefit of all the knowledge possessed here on post-conviction, perhaps a different argument could have been made. But since we're judging whether or not Mr. Rogers rendered constitutionally sort of permissible performance, we really need to focus on what he knew. There's nothing in the post-conviction hearing showing that he knew this, or at best what he should have known. And there's really no indication in this record that he should have been investigating another person with the sort of unusual nickname Domo. Instead, what we have is...
Do the tweets themselves not establish that? Because I'm again, looking at the record just as briefly as I have. It's going to take a little bit more time to digest what those tweets actually mean. But if they're retweets?
So some of the tweets, at least some of the tweets are retweets, but they would all still have been messages that were affirmatively sent by Mr. Linzy. All of the tweets discussed in the post-conviction hearing were messages sent by Mr. Linzy. Some are certainly retweets, but frankly, I think when it comes to how trial counsel should have dealt with those, there's still statements that have, I guess in the most charitable view towards Mr. Linzy, been adopted by him that he's advancing. You know, if he affirmatively, authors a statement, I don't like Dominic Johnson, the victim, that's obviously problematic. Were that a tweet? If he retweets somebody saying, I don't like Dominic Johnson, that seems to be of little difference to him, potentially little difference to him, and I think that brings us back to the way, not necessarily how Mr. Rogers objected on these authentication grounds, which was a fairly hot button issue at the time. I believe Burns had just come out. And was in fact, I think the direct appeal from this case is the first time Burns has ever sided. So he's pursuing this sort of developing legal issue. But when it comes to sort of, once they're admitted, attacking them to the jury, which is I think the other way the trial court might take issue with his performance, he's got a pretty clear strategy of, gosh, there's just no way to know who sent these. I just stated to Your Honor that we know they were all sent by Mr. Linzy's account. What Mr. Rogers is arguing is we don't know they were sent by Mr. Linzy, and he goes, I think, pretty effectively expose that at trial. I believe he obtains testimony from Devontae Blair that Mr. Blair himself had access to Mr. Linzy's Twitter account because Mr. Linzy would log into his Twitter account through Mr. Blair's phone. So he hits this note several times with Mr. Blair that we just don't know who authored these. We don't know who sent these. They're from Mr. Linzy's account. Anybody could have been the person that chose to retweet them or type them and hit send. That's what he's attacking. We don't know who hit send. That's clear strategy. And the trial court seems to me to essentially be saying, well, if I were trial counsel and knew this information that, again, it's not clear from the record that Mr. Rogers even knew, if I knew this information, which you may not have known, I would have pursued a different strategy than you did. That sort of Monday morning quarterbacking is not what ineffective assistance of counsel review is supposed to be. What we have in the record is Mr. Rogers thoughtfully and sort of vociferously objecting to these being admitted. And then once they're admitted, he doesn't roll over. He vigorously attacks the weight of the tweets through this authorship. And he well could have thought that advancing, maybe this retweet argument, he might well have thought, that gets a little murky because there's this question of, is that just adopting another statement? Does that even matter? And the problem, and I think really the flaw in granting relief here is Mr. Rogers was on the stand. He could have been asked, why didn't you make this retweet argument? Why didn't you focus on Dominique Booker? Did you know about Dominique Booker? Could have been asked, but he wasn't.
What was the focus of the trial court's prejudice analysis or determination?
I think it's a combination of, I think the trial court says is it can fathom no reason why he wouldn't have done this. Of course, part of the problem with that is Mr. Rogers should have been, why he wouldn't have presented the Dominique Booker and retweet information. Part of the problem is Mr. Rogers could have and should have been asked that, and he wasn't. The trial court also seems troubled by the absence of the actual exhibit that contained the tweets. I believe it's Exhibit 60 from the initial trial. Seems to have just gone missing. And the trial court seems troubled by that. And I think something that troubles the state is the trial court notes that it's missing and then unabashedly says, I must then speculate about what the jury did or did not know. So I think the trial court sort of combines this frustration or dissatisfaction with the missing exhibit, speculates about what effect that may have had on the jury, and then combines that with the Dominique Booker information and the Twitter metadata information. I mean, it does sort of just push all those together and then grant relief.
Okay.
I see that I'm out of time. I'd like to reserve the remainder for rebuttal.
Thank you.
Thank you, Your Honors.
Morning.
Good morning, Your Honors. May it please the Court, Chloe Akers for Jabriel, Linzy. Your Honors, I'd like to start by kind of 30,000 feet up to put this into some context, which I think will be helpful. Without any physical evidence linking Jabriel Linzy to this homicide, the state's case had significant weaknesses around identity and premeditation. To resolve these weaknesses, the state relied almost entirely on a set of 10 Twitter messages that it claimed showed Mr. Linzy did not get along with Mr. Johnson.
2 eyewitnesses?
There were 2 eyewitnesses, one of whom testified at the trial that he had known Mr. Linzy since he was a young kid. They played football together. When he reported the shooting to 911, the 911 operator said, "Do you know who fired the shots?" Mr. Blair said no. The same Mr. Blair who admitted he grew up with Mr. Linzy.
But he testified at trial and identified the defendant as the shooter.
Correct. And when he called 911, he claimed he didn't know who the shooter was.
And the jury did not accredit anything in that 911 call. They accredited his testimony that the defendant was the shooter.
Correct, Your Honor. And here's what I would say to that. The Twitter messages likely resolved any doubts that the jury otherwise would have had given the contradictory testimony of Mr. Blair and the delayed testimony of Daisha Johnson. That's why we're here. The state and I can agree on one thing. This evidence was used to establish motive. When you have motive, it shores up any doubts about ID, and it shores up any doubts about premeditation. While motive is obviously not an element of first-degree murder, it's extraordinarily helpful when proving identification. And in a case such as this, the Twitter evidence was the only independent evidence to suggest there was quote-unquote bad blood between Mr. Linzy and Mr. Johnson. It was the Twitter evidence that the state relied on to prove motive. It was motive that the state relied on to shore up the doubts that were generated by the very weak and contradictory testimony in this case. The state referred to these posts 12 times in its closing argument. They used these posts to weave together an argument that despite the doubts raised by the weaknesses of the evidence, the jury could conclude Mr. Linzy committed the crime because of what the post showed. From the state's closing, the state argued, this case began before October 3rd. It began when Mr. Linzy and Mr. Johnson did not get along. You'll know that from Exhibit 60, the comments Mr. Linzy posted about Mr. Johnson. The state continued, Mr. Johnson's life was taken because Mr. Linzy chose to arm himself, chose to follow through with some silly threats he'd made on Twitter, and again, spend time with these Twitter comments that show his state of mind. That's from the state's closing. Here's the problem. Trial counsel didn't ask a single question on cross-examination about these Twitter posts. The state claims that trial counsel vigorously attacked these posts in his closing. This is a direct quote from trial counsel in closing. With regard to the Twitter evidence, trial counsel told the jury, quote, take it for what it's worth.
Well, the only thing that's problematic about this case and your argument is that trial counsel did object on authentication grounds to the admissibility of the tweets. The court ruled against him. He objected, raised it in his motion for new trial, raised it on direct appeal, and he lost. The law was against him. So under typical circumstances, that survives because he did object. So you need to help me understand
Sure.
why that is not, that's traditionally how post-conviction really works. Lawyers are permitted to engage in strategic, decisions to defend the case as they see fit. And this lawyer, if you look at it, he objected to the evidence you say was problematic. It was just not the objection that you say he should have made.
Correct. I think the bigger concern is the fact that he didn't attack this evidence in trial in front of the jury. And if you'll allow me, Your Honor, what we know about these tweets that the trial court learned for the first time 7 years after Mr. Linzy was convicted, what was never presented to the jury is that of these 10 tweets, only 2 of them were even posted in the same year as the homicide. And neither of those 2 tweets referred specifically to the victim's screen name. Of the 8 remaining tweets, all of those were posted in 2013. The homicide happened October 4th, 2014. Of the 8 remaining tweets, they were all posted in 2013. Only 3 of those referred to the victim's screen name specifically, and none of those 3 that referred to the victim's screen name contained a threat. The court also learned for the first time at the post-conviction hearing about a material and readily available witness, Mr. Garfield Adams, who would have testified, if called to trial, that Mr. Linzy attended school with Adamo Booker, that they had had a exchange at school, a fight at school, and that's the subject of what Mr. Adams would have testified to.
Let me ask you about the tweets. You said the jury attacked the tweets in front of the jury. Page 25 of your brief, as they are here, is that how they were presented to the jury?
Well, that's a great question, Your Honor.
How were they presented to the jury?
I have no idea because Exhibit 60 is missing from the record. So all we know about what the jury learned regarding the tweets is what was read aloud to them by the detective when he testified. He did not read times, nor did he read dates. So if we had Exhibit 60 and we knew what went back to the jury, and we were able to see whether the jury was made aware of the time and the date, we would be in a very different situation. Go ahead.
Were these exhibits from the post-conviction hearing?
Those exhibits were introduced from the actual Twitter records that were introduced at the post-conviction hearing, correct. So what we know from the actual Twitter records is that of the 10 posts that were read aloud to the jury, only 2 were even posted in the same year as the homicide.
So you say actual Twitter records. You subpoenaed the Twitter account information? I mean, help me understand what you...
So there's a full Twitter record which comes back, which is 5,000 pages. And I did not, in candor to the court, I was not litigating the post-conviction hearing, the proof at the hearing. that was previous counsel. I was retained afterward. Previous counsel, without objection from the state, was able to pull the actual Twitter records for each of the messages that the detective testified to at trial, introduce that to the post-conviction court, which showed that while these messages were read aloud to the jury, what was never read aloud to the jury or ever argued to the jury was the timing of these messages, whether they were retweets, whether they were talking about the victim's screen name or a completely different screen name, or no screen name at all, just the words Damo.
So how do we know what was presented to the court at the post-conviction hearing was the same thing that trial counsel had at trial access to?
Because trial counsel testified at the post-conviction hearing, he reviewed all 5,000 tweets.
Okay.
And so where we are is a situation that the state of Tennessee was able to use Twitter records in such a way as to show a motive. They argued these showed his state of mind. I mean, that's a direct quote from the state's closing. Spend time with the Twitter comments that show his state of mind. Except the Twitter comments from 2014, which were April of 2014 and February of 2014, before a homicide in October of 2014, those two messages that were even in the same year as the homicide didn't reference the victim at all. This is crucially important information when you recognize that the Twitter posts were what the state used to prove motive, and it was motive that the state used to compensate for the weaknesses of the identification testimony. It is incredibly critical when you're arguing that Twitter posts show a state of mind that the jury be informed that these posts were from a year and a half, 18 months prior to the homicide, that the two posts even in the same year didn't reference the victim's actual screen name. So the issue here that the trial court found was trial counsel's way in which he addressed these messages at trial. Trial counsel testified at the post-conviction hearing. His defense theory was to, quote, attack the evidence against Mr. Linzy. Trial counsel also closed his case to the jury by stating, and I quote, that there was nothing in the state's case that pointed to Mr. Linzy being the shooter, quote, except for this Twitter. That was defense counsel's words to the jury in closing.
But he had a strategy. It's not as if he did not have a strategy in this case. Do you agree that he had a strategy?
Absolutely. His strategy was to attack the evidence that linked his client to the case. The only problem is, by his own admission, the most important piece of evidence that linked his clients to the case was the Twitter posts, and he didn't attack those before the jury. He didn't ask a single question about the Twitter posts during the trial. Not a single question on cross. Detective, when were these posts made? Detective, when was the homicide? Detective, what's the difference between Damo YOLO Gray and Damo 400?
He had a bad strategy.
No, I'm saying that he had a strategy to attack the evidence, which is generally speaking a pretty good strategy. But when you don't attack the evidence that you yourself concede is the singular most important piece of evidence linking your client to the case, the court rightfully concluded he could fathom no reason not to have done so. Trial counsel had a strategy to attack the evidence. He just didn't attack the most important piece of evidence. That is why the trial court correctly concluded that it could fathom no reason not to have done so. There is no reason to sit next to Mr. Linzy, knowing you're going to trial to attack the evidence, conceding to the jury that these Twitter posts were the most important piece of evidence linking his client to the case, and just never mention that they were posted a year, 18 months prior, never mention the difference between screen names. We talk about the evidence of Garfield Adams. Trial counsel heard the trial, pre-trial hearings, the post-conviction testimony. Kit Rogers, trial counsel, testified that he met with Mr. Linzy 2 to 3, maybe 3 to 4 times before this first-degree murder case. He had 3 months to prepare. 2 to 3, maybe 3 to 4 times, and trial counsel admitted that at least 2 of those meetings were in the week before trial. Trial counsel testified that he reviewed all 5,000 tweets. Trial counsel testified that he remembered Mr. Linzy saying something to him about a fight at school. Well, one of those 5,000 tweets that counsel testified that he reviewed stated, "I might have to beat on Damo if still here during class change." And Damo is not Damo 400, which was the victim's screen name. It's just the word Damo. So counsel has a duty to investigate. And by the way, that one tweet, "I think I might have to beat on Damo if still here during class change," April 8th, 2014. That was the tweet that was the closest in time to the proximity of the homicide. Didn't even reference the victim's screen name. If you know this is a murder case, and you know the Twitter records are important, and you've testified that you've reviewed all 5,000, and you've testified that your client told you that he got into a fight at school with someone named Damo, recall testimony about that, you have a duty to follow up and investigate. There is no fathomable reason not to have done this when the defense theory, and Your Honor is absolutely correct, was to attack the evidence. The trial court made 4 factual findings in this case. 1, that it could fathom no reason not to have presented it. And in the totality of the circumstances, this makes sense. If your theory is to attack the evidence, and the most important piece of evidence is a Twitter post, and you never argue a word to the jury, what that enabled the state to do was mischaracterize these tweets to suggest there was some bad blood. Now, of course, the state could have still made that argument in its closing. But imagine the difference it would make to the jury if counsel got up and said, "Well, these tweets don't actually show bad blood. They were made a year and a half before. Was
there any other evidence in this case concerning the relationship between the defendant and the victim in this case?
None. I would also point out the trial court's findings regarding factual findings as regarding prejudice. So as to deficiency, made the factual finding it could fathom no reason, which I think is abundantly clear when you understand the way in which the state was able to use the messages as a result of counsel's treatment of them. As to prejudice, the court found that the case centered around the eyewitness testimony of DeMonte Blair and Daisha Johnson. And there were weaknesses in that testimony, which, yes, the jury obviously discarded, in large part because the state was able to claim there was a motive. Because defense counsel failed to properly address and attack the evidence, the state was able to make that claim. The court found that these contradictory and delayed eyewitness testimonies were significantly bolstered by the Twitter evidence. Of course it was. It was motive. Motive bolsters ID and premeditation. And finally, the court made the factual finding that the absence of critical information that was readily available, the dates, the times, the context, would have impacted and mitigated the impact of the posts.
And you agree with the state that we're bound by those factual findings?
Oh, yes, absolutely, Your Honor. And I don't believe that the state has presented evidence from the record to preponderate against the court's factual finding in this case. That the reason trial court's factual findings are given the deference that they are is that Judge Green sat through this entire trial. And I think it is critically important to really understand that this case is about how the state was able to use the messages to weave an argument. They overcame the weaknesses by proving motive with posts that didn't actually show what the state was able to argue they did. When you are telling a jury to refer to Twitter posts to show a defendant's state of mind, and defense counsel just never gets up and says, state of mind. Ladies and gentlemen, these posts were from 2013. And heck, the vast majority of them didn't mention this victim's screen name. And the 3 posts that mentioned this victim's screen name didn't contain any threats. None. And 2 of those 3 posts that mentioned the victim's screen name, none of which contained any threats, they weren't even written by Mr. Linzy. The state claims that the defense had this great theory about authorship, that, oh, it wasn't Mr. Linzy, somebody else could have written those. Well, there was evidence that somebody else did write them. That's what a retweet is. But Mr. Rogers, trial counsel, never said that to the jury. If your whole argument, trial counsel testifies his theory is to attack the evidence, he fails to attack the singular most important piece of evidence as he acknowledged it in closing. But even if, as the state claims, he was really giving it his all to attack authorship, there is no fathomable reason why trial counsel wouldn't have pointed out to the jury the number of these tweets that were definitively authored by someone else, as insofar as they were retweets. What this case comes down to, in my opinion, and it is rare to have an ineffective assistance of counsel claim granted in the trial court. This is a situation where it was absolutely justified. Jabriel Linzy was 18 years old by about 2 weeks when he was arrested. He was convicted and sentenced to life in prison at 19 years old. His lawyer was appointed to him 3 months before this first-degree murder case, and by his own admission, only met with him 2 to 3 or 3 to 4 times. There is no physical evidence whatsoever linking Jabriel Linzy to this shooting. There is weak and contradictory eyewitness testimony that was shored up through the use of these tweets.
And I hate to be doing really, really well. I hate
That's
to
okay.
mess you up.
Go ahead.
The surviving victim, did the surviving victim testify that he had known the defendant prior to the shooting?
The surviving victim, Mr. Blair, testified that he had grown up with Mr. Linzy. They had played football together, and that he knew him well before the shooting, which is why it was so odd that when the 911 operator asked if he knew who shot at him, he said no, which is why the tweets were so critically important, because they were able to show a so-called motive which overcame those serious doubts, which is why Mr. Linzy was prejudiced in this case. Which is, in fact, exactly what the trial court found, that the state's case centered on the eyewitness testimony of Mr. Blair and Ms. Johnson, and the trial court found that that testimony was, quote, significantly bolstered by the tweets, and that the lack of contextual information would have made a difference to the verdict in this case, as it undoubtedly would have. The trial court's factual findings have not been overcome by anything that the state has alleged. In fact, the state is asking this court to Monday morning quarterback the trial court without actually presenting evidence as to why the trial court was incorrect on its factual findings. The court, the state is saying that the trial court made the wrong legal determination, but the court made the absolute correct legal determination given the 4 factual findings it concluded, which require proof to preponderate against them, and the state simply has none. This is a situation, a rare situation, where the trial court undoubtedly considered this evidence. We had a post-conviction hearing. I was hired to brief the post-conviction hearing, 60 pages. We had multiple arguments. The court considered this diligently over a period of months. And after having sat through this entire trial and seen the evidence, made these 4 factual determinations, which led to a very, very appropriate post-conviction ruling.
With my colleague's permission, may I ask a question?
No, certainly.
If I heard you right, counsel, did you say that it's your contention there was no other evidence besides the tweets, except as to any bad blood between Mr. Johnson and Mr. Linzy?
There was, Ms. Daisha Johnson testified she didn't know about the relationship. Timothy Spears testified that he didn't independently know about the relationship between the two, that he had seen them interact once at a county fair about a month before the shooting, that they had, quote, words exchanged, but according to Mr. Spears, he testified, and I quote, it was nothing severe.
Did he also say, as in the state's brief, and they quote the trial transcript, that this altercation between the two left Mr. Johnson shaken?
Mr. Spears said that the words that were exchanged between Mr. Johnson and Mr. Linzy at the fair left Mr. Johnson shaken, but that it was, according to Mr. Spears, quote, nothing severe. So Mr. Spears testified as to seeing one interaction between the two, but he did not testify as to a long-standing bad blood or feud. He was only able to testify as to seeing one limited interaction that he described as nothing severe. And so, as I understood the original question, it was whether there was other evidence as to the relationship, the long-standing relationship, if any, between Mr. Linzy and Mr. Johnson, and that wholly was generated by the Twitter posts. I hope that clarifies your question.
All right.
I apparently, in a modern miracle, I seem to have more time, and it's very unusual that I would finish early. If the court does not have any questions, I would ask you to.
I think the red light.
Yeah, it's
you're
been
out.
Oh, okay. Your Honor,
We thought you were kidding.
Me. I'm actually, this is my first oral argument and likely my last because I'm not practicing anymore. And so I kept looking and, okay, this all makes sense. Thank you very much, very, very much for your time.
Yeah.
I'm glad you said something or I would have gone. There's no telling how long.
The yellow light means you got a little more time, but the red one means you're done.
Well, that makes sense.
Yeah, just like a traffic light, sort of. All right, General, you have rebuttal.
A couple brief points on rebuttal, Your Honors. One, I think the first and most important is something, Judge McMullen, that I think has troubled you about this case and that has troubled me about the grant of relief, is that Mr. Rogers clearly had a strategy for excluding this evidence, and I'd say clearly had a strategy for attacking it to the jury. I heard my friend on the other side suggest that he simply didn't do this. That's just in direct contradiction to the record. Exhibit 1 to the post-conviction hearing, Exhibit 4, Volume 4 is his closing argument. And if I may quote from my brief here, because I believe I have his quote presented in his closing argument, he says to the jury, there is simply no way to know who sent these tweets. So his strategy, he's attacking authentication to exclude them. We don't know who wrote these tweets, who sent these tweets, who hit send. It's exactly what he does to the jury at closing. And he does the same with Devontae Blair. It's simply not the case that he doesn't exercise this strategy during testimony. When Devontae Blair is testifying and Blair directly testifies, yeah, I saw bad blood between them on social media. So Mr. Rogers asks Blair, okay, well, could anybody else have logged into his Twitter account? And that brings me back to what I discussed with the court during my principal time. He with Blair exposes to the jury, we simply don't know who pressed send. That's his strategy. And I think what this really boils down to is perhaps the post-conviction court and my friend on the other side are sitting here reviewing this saying, oh, we would have maybe taken a different strategy than Mr. Rogers did. Maybe that's would have been a better strategy. My friend on the other side made a compelling argument about how she would have used some of this information. But the standard for ineffective assistance of counsel is more or less, was Mr. Rogers making an informed strategic decision, not did he make the best strategic decision?
I think that's where I am, counsel, and you can, close however you see fit. Strategy, you well know that we afford lawyers, the benefit of strategy at trial on post-conviction, but it's whether it's informed strategy and ill-informed or failure to enlist or employ a strategy, ill-informed strategy, is where we start to have problems. And I think that is what I'm hearing from your friend on the other side, is that, yeah, he employed a strategy, but it was not well-informed based on these tweets that we are all eager to see.
I think frankly, Your Honors, it's difficult to make that argument in this case because there is precious little asked of Kit Rogers about essentially how informed were you when you made this strategic decision, which I think we all have to agree he made. There's simply not really any examination of him of why did you do authentication instead of this argument that's being advanced on post-conviction. Did you even know you could make this? Did you know about the timing? Did you know about the retweets? He needed to be asked, and he wasn't. So I think it's difficult to look at the record in this case, the trial record, and then the post-conviction, and suggest he was ill-informed. With the court's permission, if I may make a brief point about the missing exhibit. There's a missing exhibit here. We don't know exactly how these tweets were presented to the jury. On post-conviction, it's the burden of the defendant to establish things. To the extent there's some lack of clarity, that cuts against the party who bore the burden. I think there's some similarity between this and when trial counsel passes away between trial and the post-conviction hearing. That doesn't shift the burden. So to the extent, as the trial court unabashedly did, it speculates about what may have been in this and then uses that speculation to grant relief. That was improper.
The judge who heard the post-conviction, was he also the judge who presided at the trial?
I believe so, Your Honor.
Usually,
the only point I'd make is that there's I don't want to say, I hesitate to say extraordinarily, there's a long period of time between this trial and I believe it's 6 or 7 years between the trial and the post-conviction hearing. And I hesitate to say what I remember about even appeals I handled 6 or 7 years ago, much less a trial if I were a trial court with a full docket.
Well, that judge heard everything at the trial, and then he heard everything at the PC hearing. And basically, to put it in non-legal terms, it sounds like he or she came to the conclusion that this defendant should get a new trial, basically with the kind of cross-examination and legal assistance that's been demonstrated by post-conviction counsel up here. Well,
That is in essence, Judge Wiedemeyer, what he did. The problem with this is the standard that Mr. Rogers was held to was rendering constitutionally permissible performance.
Right.
And if he has an informed strategy, which I'd strongly suggest to this court, the trial record and the post-conviction hearing record demonstrate that he did.
Well,
that's the end of the matter.
As we point out numerous times, we're here to correct errors, and so if we're to go give you the relief you're asking for, we would have to say when the trial judge / PC judge came to that conclusion, made an error. That issue is mixed fact and law and de novo review, right?
Correct, Your Honor.
Okay.
And the state's primary contention here is that the trial court made a legal error in determining that deficient performance was shown, even based on the factual findings that are present in the order. That legal error, that legal determination is reviewed by this court de novo.
All right. Fair enough. Thank you.
Thank you.
All right. Well argued and excellent briefs. All the cases this morning qualify on that, so we'll take it under advisement. Thank you. We'll be in recess till 1 o'clock today, correct? All right.